All right. Well, good morning, everyone. My name is Rebecca Green. I'm a shareholder in our employee benefits practice here at Reinhardt, and today I'm going to go over some basics of ERISA and fiduciary duties, which are the rules governing employee benefit plans. So let's get past the housekeeping. So we're going to start with very briefly kind of identifying how you become a fiduciary and then what those fiduciary duties are. And then we're going to kind of move into the meat of the presentation. How do you minimize liability for fiduciaries, and then things that hot topics and trends for fiduciaries in the employee benefit plan world. And as you might imagine, with a lot of other areas of law right now, given the recent election of President-elect Trump and the control of the White House and both houses of Congress moving to the Republican Party, we will be expecting, I think, some changes from current administrative practice by the agencies. The agency responsible for policing ERISA fiduciaries is the Department of Labor, which is, and the subgroup of the Employee Benefits Security Administration is specifically tasked with that responsibility. That's headed by Phyllis Borsey. I would imagine the new head of the EBSA after President Trump is inaugurated will take a different approach. We don't yet know what that will be, but a lot of the things that we're going to discuss today are fundamentals. So I wouldn't expect a lot of that to change, but certainly some of the policy initiatives are going to change, and we'll just have to monitor that as it happens in 2017. So first of all, who is an ERISA fiduciary? And there are two types of fiduciaries in ERISA. There's the named fiduciary of a plan, and this is an ERISA requirement that every employee benefit plan, whether it's a retirement plan or a health and welfare plan, has to have a named fiduciary. And then there are also fiduciaries that you can become a fiduciary by performing a fiduciary act, referred to shorthand here as a functional fiduciary. So every plan has to have at least one named fiduciary, and the named fiduciary is usually named in the plan document itself. To the extent the plan document does not say so-and-so is a named fiduciary or such and such officer is a named fiduciary, the default under ERISA is that the plan sponsor is the fiduciary, and very often the plan sponsor is going to be the company or the employer. To that extent, anytime you have a company as your plan sponsor, of course the company acts through its board of directors. So one thing to keep in mind is when the company is the plan sponsor, which is typically how you want it set up, and then the board of directors is acting, if the board of directors is asked to take any fiduciary action, it is possible that the individual directors could be considered fiduciaries. So that is one reason why it's a very good idea to get that fiduciary responsibility delegated away from the board, so that the individual board members who are probably going to be quite removed from day-to-day operations of the employee benefit plans of that employer, get them out of that role. As far as a functional fiduciary, you can be a fiduciary if you exercise any discretionary control over plan administration, if you render investment advice for a fee, or you have any control whatsoever over plan assets. For this reason, company officers who are typically tasked with administering the plan or are responsible for directing the custodian of the plan's assets, for example, a 401k plan, what to do with those assets, those individuals are going to be fiduciaries to the extent they are taking a fiduciary action with respect to those assets. And that leads us into this two hats doctrine. Not everything that an employer is tasked to do with, not every activity that you have to do with an employee benefit plan is a fiduciary act. There are actions that are generally called settlor actions, and those are actions those are not fiduciary actions, and they are when you're taking a settlor action, you are not acting as a fiduciary. The same individual, say that you're director of HR, very often the vice president of HR, the director of HR, is going to be the one kind of responsible for day-to-day administration of a plan. And to the extent that HR professional is deciding a benefit claim, maybe somebody has applied for a hardship withdrawal from the 401k plan. If the individual who is then reviewing that application and deciding to approve it or deny it, that's a fiduciary act. But then let's say in the same day or a different day, that same individual is working with the chief financial officer of the company to decide what the company match is going to be for the upcoming year. That is a settlor act. That's a plan design decision. That's not a fiduciary act. The same individual was performing both actions, but that director of HR was acting as a fiduciary in one instance and as a settlor in another. And these things are very important it's important to understand when you're acting as a fiduciary and when you're not acting as a fiduciary, so that you can document those things separately and not have those activities bleed over into one another, perhaps, and then also not using the appropriate standard of care when performing those actions. So other settlor functions to keep in mind are any plan design decision, deciding whether to amend your plan to change the match, add a match. This is a 401k. Health plans, for example, anytime during insurance renewal, I assume there are always decisions to be made about what benefits are offered, what plan to offer, what insurance company to go through if you have an insured plan. All of these are settlor functions, and in deciding those making those decisions towards settlor functions, you do not have to follow the ERISA fiduciary duties, which we'll get to in a minute. So that's the important distinction there. But then, of course, once a settlor decision is made, for example, what is the match? When the employer makes the match to the plan and then the match is allocated to plan participants, that act of allocating it, allocating the match and following the plan document and doing so, that's a fiduciary function. Let's see. Let's move ahead. Okay, so these are, when you're acting as a fiduciary, when an individual is acting as a fiduciary, these are the 5 fiduciary duties that apply. The duty of loyalty, duty to act prudently, the duty to diversify plan assets, the duty to follow plan documents, and the duty to avoid prohibited transactions. All of these duties are found in ERISA Section 404, and violations of these, failure to comply with these duties or failure to act in accordance with the standards set forth for one of these duties can result in personal liability to a fiduciary. So that's why it's very important to understand when you might be acting as a fiduciary, or a member of your organization is acting as a fiduciary duty, and following the fiduciary duties when required. So let's see. So the duty of loyalty. This duty requires that all activities and transactions be taken on behalf of a plan as a fiduciary must be for the exclusive purpose of providing benefits to plan participants and defraying the reasonable expenses of plan administration. This is one of the highest duties known unto the law, and all fiduciary actions have to be taken for the exclusive purpose for the benefit of participants. You're not supposed to be, as a fiduciary, also considering the business implications of that decision when making a fiduciary decision. There may be a follow-on benefit to the company from a business perspective, but that cannot be a deciding part of the decision-making process, if that makes sense. And then the second bullet is important. The fiduciaries must be truthful with participants regarding plan terms and plan status. This is the rule that says if a participant asks you a question, you can't lie to them. This rule does not require the plan sponsor to reveal non-public information or to volunteer information. it really is if you're asked a direct question, you have to give the answer. You can't be misleading. The only exception to this where the plan may have to volunteer information is if the plan sponsor is aware of an upcoming plan design change that is under serious consideration, and a participant asks a question that would potentially, maybe the answer would be impacted or their decision might be impacted by this upcoming plan design change that's under serious consideration, the plan sponsor may then have, or the fiduciary may have, an affirmative obligation to let the participant know about that. And best example, most recent example I've come across is when plan sponsors might be deciding with a pension plan to undergo what's sometimes called a lump sum distribution, or a window lump sum distribution, where they offer a one-time opportunity for terminated participants to take their benefits out of the pension plan in a lump sum. It's a pension de-risking technique that is very popular right now. So the decision to offer that lump sum window, that's a settlor decision. That's not a fiduciary decision. But once the lump sum window is under serious consideration, if a participant asks, say, the HR director, I'm trying to decide whether I should retire now, or if I should wait, or if I should elect my benefit now, or wait 6 months, the fiduciary would be under an obligation to let that participant know that there may be this window lump sum option coming up, and if they were to elect a benefit now, they wouldn't be able to participate in it. So that's kind of that's where the fiduciary may have an affirmative obligation to disclose information that's not already available to a participant. The duty to act prudently, this is commonly called the prudent person rule. Anytime a fiduciary is acting, the fiduciary must exercise the same care, skill, prudence, and diligence that another prudent person would exercise in similar circumstances. This is basically the obligation good faith is not enough. You have to know what you're doing, and if you don't know what you're doing, you have to become educated to do so, which is typically why most plan fiduciaries hire service providers and other experts to advise them in running their employee benefit plans. The way that you document compliance with this duty is to keep records, detailed written records of your process as a fiduciary. That is what courts would look to if there's ever an allegation that a fiduciary breaches his or her duties. Courts and agencies look back to the records of the decision-making process as it was documented at the time of the decision. Courts have often said that post hoc rationalizations are not sufficient. So you do have to document on an ongoing basis all the different decisions made by a fiduciary, which is why it's a good idea to have formal, if you have a committee or a couple of individuals who are responsible for administering your employee benefit plans, it's a good idea to have regular formal meetings or sessions, and then be documenting what is discussed during those meetings or sessions, either in minutes or outlines, something of the sort that is retained in the company's records, so that if an agency ever were to question the prudence of an investment option, say in the 401k plan, the plan fiduciaries would be able to go back to their records and say, here is the meeting minutes showing when we added it and our discussion about why we added this option, and then here annually we can show that we monitored that investment option and determined that it was still remained a prudent investment option. Just as an example of how things can go haywire, Boeing was one of the original companies sued when the 401k fee litigation really took off in the late 90s. And in 2000, the case was finally settled in 2014 or 15, and many of the issues in that case related to the investment options offered under the Boeing 401k plan, and Boeing did not have good records showing why they added investment options, why they kept investment options. They had they didn't have good records showing that they were monitoring those investment options, and ultimately Boeing ended up settling the case for $57 million to avoid trial. And so Boeing's a very large company, and that's a lot of money, but it's just one example of how the failure to document your decision-making process can bite you in the end. This next one, the duty to diversify, it's one of the, I think this is one of the best known duties, because most 401k plan sponsors are well aware of this, because in order to get the protection of a section of ERISA called 404C, which is the section that basically says plan fiduciaries are not responsible for the investment selections of the participants when you allow participants to select their own investments in a 401k plan. In order to comply, to get that protection and be a 404C plan, you have to satisfy some fairly regimented diversification requirements. So many fiduciaries are already familiar with this rule. This rule also applies to pension plans. And it's basically that plan investments have to be diversified to minimize the risk of large losses. Under ERISA, for a pension plan, for example, there are no bright line rules. ERISA doesn't say that a mix of 60-40 equity to fixed income is appropriately diversified. Unfortunately, ERISA doesn't give us any bright line rules about how to satisfy these fiduciary duties. So it really is up to the fiduciaries to consider a variety of factors in deciding what level of diversification is appropriate. And those factors are what you would imagine: the size of the plan, the financial and industrial conditions in the market, the different types of investments that are available, different investment classes, those investments' geographic distribution, their maturity, and the purpose of the plan. For example, diversification in a 401k plan is very different than diversification in a pension plan. So that's one thing that the fiduciaries, this is something fiduciaries are probably fairly familiar with, but this is part of the duty, and it should be documented on at least an annual basis, if not more frequently, monitoring the investments of any plan to satisfy this duty. The duty to follow plan documents. This duty applies, or comes into play most often in the administration of a plan, and it arises, the way that the failure to follow plan documents comes up when mistakes get made in plan administration. For example, a 401k plan that does not, in the plan document, the plan doesn't allow loans, but the participant was allowed to take a loan from their 401k plan account. Technically it's a failure to follow the plan document. It's a fiduciary breach, but it's also it's a little bit beyond the scope of this presentation. It's also a failure to maintain the tax qualified status of the plan. So the failure to follow plan assets is typically remedied by correcting those mistakes through the IRS's Employee Plans Compliance Resolution System. It's a very robust correction program, opportunities to self-correct those issues, and that's typically how plan fiduciaries fix the failure to follow plan documents. And then this duty, this is the duty to not do something, the duty to avoid prohibited transactions. And this is, the prohibited transaction rules of ERISA are the crux of ERISA. When it was originally passed, it became law in 1974. The years leading up to the passage of ERISA saw a number of plans fail due to the bad acts of the people running those plans, in charge of those plans, and a lot of them involved self-dealing in some way. So that's why ERISA came up with these very, very specific and broad, all-encompassing list of prohibited transactions. There's two types of prohibited transactions: the party and interest transactions and the self-dealing prohibitions. The party and interest transactions prohibit a plan from engaging in a transaction with a party in interest that is a transfer of goods or services between the party and the plan. This includes extensions of credit. It includes using plan assets to pay for service providers. The majority of typical activities that are required to run a plan are going to fall under one of the exemptions from this prohibition in ERISA Section 408. As a general rule, plan sponsors are going to be able to engage service providers to assist them in running their plans as long as the contracts and the arrangements for those services are reasonable and the fees specifically are reasonable. The self-dealing prohibitions, there are no exemptions for these. These are the really bad ones. These are the, you can't steal from the plan, and then more broadly, fiduciaries are also not allowed to act in any transaction for their own benefit or take any action that is when they are in a position to also be adverse to the plan. So these are the self-dealing prohibitions, no exemptions for the party and interest transactions. There are lots of exemptions, and you just have to make sure that if the plan is going to enter into some sort of arrangement, that there is an exemption and that you follow the terms of that exemption. An example of a case where a plan sponsor was found to have or run into problems following this rule is there was a Cigna, the big health insurer, was sued for its own 401k plan. The issue in the Cigna case involved Cigna having a stock fund in its plan, and also had offered as investment options in its 401k plan investment options that Cigna itself managed. And in doing those, when Cigna was offering those options and managing those offering the stock fund and then also offering the investments of Cigna managed, Cigna as a corporate entity received what was found to be impermissible benefits. So when the case settled in 2013, even though Cigna has continued to deny any wrongdoing, it did agree to a number of changes, including that it would not be allowed to offer investment options that were advised by Cigna or a Cigna subsidiary, and it was required to hire independent third-party monitors to ensure that the investment options offered in a Cigna 401k plan did not result in impermissible benefits to Cigna. All right, so how do you, if you are an ERISA fiduciary and you have to follow all of these rules, how do you minimize your liability? How do you protect yourself from allegations of or actual breaches of the ERISA fiduciary duties? So there are several ways to minimize liability, and I would posit that many employers do all or most of these things. It doesn't hurt to annually, or not annually, a regular periodic basis, revisit a lot of these items, minimizing liability, these ways to minimize liability, and to see if the employer can implement them or improve on existing practices. So fiduciary training is a fairly simple one to do. There is no mandate to provide fiduciary training for fiduciaries of your organization. It's not required under ERISA, but is definitely considered a best practice. We have found in recent DOL audits, routine DOL audits, that they often ask for any fiduciary training materials or documentation of fiduciary training that's been provided to the fiduciary. So it's definitely something that the Department of Labor has on their radar screen and views favorably. The DOL does not have an expressed preference for any type of specific training. It doesn't have to be formal. We tend to advise our clients, we think that a good mix of formal and informal is probably a wise choice. Formal training being the type of programs, formal programs put on where there might be certificates of completion, or like an organization like the International Foundation of Employee Benefit Plans very often puts on seminars and conferences, that type of formal training. would be appropriate periodically, and also informal training. Fiduciaries can have their outside legal counsel or their investment consultants provide informal training on a periodic basis about market conditions or certain types of investments to educate the fiduciaries before they maybe enter into that type of investment for their plan. Another point, there's all new fiduciaries. Any employee who is maybe coming on to an investment committee should get some type of training to introduce them to their responsibility, to advise them of what the fiduciary duties are, and also to document that they're aware that they have these obligations, and to educate that employee, particularly if they don't have a finance or economic background, such that they would already be aware of different types of investments and how different market conditions. Another way to mitigate fiduciary liability is to delegate your fiduciary duties, and I was alluding to this earlier. If you don't have a named fiduciary that is in the plan document that is an investment committee or an officer, and most plans do not, then legally under ERISA, the board of directors is responsible for undertaking all of the fiduciary actions required to operate the plan, and that's not really a realistic approach, nor is it a good idea for the fiduciaries or for the individual directors. So the way you address that is you delegate those fiduciary duties down to the level that's appropriate within the organization. The obligation to select and monitor investments should be delegated to an investment committee or an individual within the firm, excuse me, speaking of my own employer, within the organization who has the knowledge and the time to do that. Plan administration is typically delegated to an individual or group of individuals in the HR group or those who have HR responsibilities. These delegations should be in writing, and they should be clear. The only thing to remember about delegation, or the important thing to remember about delegation, is you cannot delegate away all of your responsibilities. When a fiduciary delegates responsibilities to another individual or committee, the delegating fiduciary always retains the responsibility to monitor that delegation, to basically make sure that the individual or committee who has been assigned that responsibility is actually doing it, and that they are capable and have the requisite knowledge to do so. All right. And another point here is one way to avoid possible confusion between settlor and fiduciary responsibilities is to delegate them to different groups. It's not required. You don't have to do that. But if the same committee of individuals exercises both fiduciary and settlor duties, say they're the investment committee and they also make plan design decisions, then that committee needs to be very careful about how they act and they undergo their decision-making process to ensure that their fiduciary duties are documented appropriately and they don't consider anything impermissible in making those fiduciary decisions. For example, by not being aware that they're acting as a fiduciary and maybe considering the organization's financial best interest in making a fiduciary decision, which of course would be not okay. Another way to protect yourself is to retain a qualified professional to either provide advice to the fiduciary or to actually take on some of that fiduciary responsibility. We're seeing a lot more of that with our clients, particularly in the investment, the selection of investment options. There are more and more investment advisory firms who are willing to take on the responsibility to actually select and monitor investment options for a 401k plan for an organization, so that your investment committee wouldn't have that responsibility. Their role would be in monitoring that service provider. Hiring a qualified service provider is a good idea. It can reduce costs, overall costs. You gain access to expertise in that particular field. It allows the employer to access superior technology, and also helps ensure legal compliance. There are some pitfalls in hiring service providers, and that's mostly on the related to the process you undergo to hire the service provider. So you have to document the hiring of a service provider for a plan is a fiduciary act. You need to document the hiring process, document the qualifications of that service provider. It is better to compare potential service providers to each other to ensure that both that the service provider you ultimately hire is both competent to provide the services, and that the fees that they are charging you are reasonable in the industry. Paying unreasonably high fees to a service provider is going to be a fiduciary violation, and this that is the hottest area of fiduciary litigation still today. Just yesterday, I saw an article that another large employer was sued for, and the claims are all based on fees paid to the record keeper, fees paid based on for investments. Fees are still the hottest area of fiduciary litigation, and has been for well over a decade. Another way that the comment here about bundled services from multiple plans, it can be risky for a couple of reasons. Number one, when a service provider offers bundled services, the fees are often less transparent and harder to evaluate. And then you also, the secondary problem there is bundled services for multiple plans can also create a problem if you're not clear how much each plan is paying for the services provided to that plan, because you would have a fiduciary violation if you get a bundled, if you have bundled services, and you have, let's say, a 401k plan and a pension plan, and all of the fees are, say, paid by the pension plan, but that service provider is also providing services to the 401k plan. In that case, the pension plan is paying too much. It's paying for services that it is not receiving. It's paying for services that are being provided to a different plan. That is a fiduciary violation. So when you are working with a service provider that offers a bundled fee arrangement, you have to be very careful that you understand exactly how that fee works to assess both its reasonableness and to ensure that the services are being paid for by the correct, from the correct pool of plan assets. This last point about termination and indemnification contract provisions are usually one-sided. Indemnification is not an ERISA issue. It is more of an employer protection issue. One thing to note is most of the off-the-shelf service provider agreements are going to have one-sided indemnification, where basically that service provider is saying, yes, we will provide all these services, but if anything goes haywire, we're not responsible, we're not liable. You need to read those contracts carefully, and work to, if you can, negotiate a better arrangement there, so at least the service provider is responsible for their own mistakes. Termination provisions, this is an ERISA requirement. ERISA's exemption for service provider, the exemption from those prohibited transaction rules I talked about earlier, requires that a plan be able to terminate the contract on reasonably short notice without penalty. So that is an ERISA requirement, and so you'll need to double check in the plan or in the contract, how much notice does the organization have to give to terminate the contract, and is there an early termination fee associated with that. The only permissible early termination fee under ERISA is a penalty or is a cost that is tied to the service provider recouping any startup costs that they have incurred in bringing and onboarding that arrangement. So follow on from that point, it would be unusual and likely unacceptable to find early termination penalties in renewal contracts. If you've been with the provider for a while and you're renewing a contract for a second term, an early termination penalty is probably not going to be appropriate because there are unlikely to be any startup costs to recoup because you're staying with the same service provider. Working with professionals. In working with the professionals you do hire, the fiduciary still have the duty to act prudently and the duty to monitor. When you hire a record keeper, for example, to administer your 401k plan, the fiduciary is responsible for periodically determining that the services that record keeper are providing and the fees remain reasonable. This goes for investment consultants and investment advisors. Any professional hired by a plan is going to have to be monitored periodically. That means at least annually. It's not I forget what the late night sales pitch or what exactly the product was, but it's not a set it and forget it. You don't hire a record keeper and then not check in on them for years at a time. It doesn't mean you have to put them out to bid every year, although periodically putting your service providers out to bid is a good idea. It allows you to compare apples to apples, and it also tends to bring your fees down when you create competition. But that is an expensive process, and it's not something you have to do every year. We typically tell our clients every 3 to 5 years it's a good idea to put your service providers out to bid to ensure that services and fees remain reasonable. All right. So one of the pitfalls of working with professionals is maintenance of the attorney-client privilege. And one thing to bear in mind about the attorney-client privilege is, while the general rule is that communications between attorneys and clients are privileged and can't be disclosed to third parties, particularly in litigation, there is a fiduciary exception to the attorney-client privilege, and it often comes into play in employee benefit plans when the allegations involve breaches of fiduciary duty, because the participants, if you're acting as a fiduciary and you obtain legal advice in your role as a fiduciary, in reality the participant is the beneficiary of that legal advice because you're acting for the exclusive benefit of the participants when you're acting as a fiduciary. So already in ERISA litigation, in litigation involving ERISA plans, there are a number of exceptions to the attorney-client privilege. And then you layer on top of that communications with your service provider are not going to be privileged. And that's usually who the organization is engaging with about the day-to-day administration of a plan. Typically that's who you would first contact, say your record keeper, or in the case of maybe a health plan, your insurance provider, about when mistakes are found or issues are uncovered. That's usually the first communication. So one thing to bear in mind as organizations administer their plans, for those of you who are listening who are responsible for any aspect of that or advising an internal business unit about that, is to highlight for them if there is a risk of a mistake being a big mistake or a litigation risk. It is always a prudent idea to stop and consult legal counsel before you proceed and start involving the universe of service providers to the plan. It may be that attorney-client privilege cannot be maintained there, but to the extent that it can, taking that action would help preserve it to the extent that you can. Okay, establishing an investment policy. This is a big one, and it's very important particularly if you are outsourcing the responsibility to select investments for your 401k plan, which is very popular. And again, it's not a bad fiduciary decision. In fact, it can be a very, very good fiduciary decision to engage an expert investment advisor to actually make investment selections for the 401k plan. But if you do that, then you definitely are going to want to have a good investment policy, because the investment policy is the guideline, the parameters within which that advisor is going to work. And even if you don't outsource that responsibility and the organization has an investment committee, for example, that selects and monitors the investment options offered under its 401k plan, an investment policy works in the same way. It is a good set of guidelines that the fiduciary then follows when making those selections, when deciding if an investment option is, should it be replaced, how should it be replaced, what are the options for selecting a replacement investment option, and so on and so forth. The common aspects of investment policies are listed there. One thing I definitely want to note is having an investment policy that you don't follow is probably worse than not having an investment policy at all. Anytime you create a policy or a procedure for an employee benefit plan and then the fiduciaries do not follow it, that in and of itself becomes a new fiduciary breach. Even if the policy or procedure wasn't required under the law, if you have it, follow it. Policies and procedures for employee benefit plans should be working documents. It shouldn't be something that you create, you hire a consultant, you create a fancy investment policy, and then you throw it in a drawer never to look at it. It is better to have a shorter, maybe with fewer bells and whistles, shorter document that gets pulled out and used by the investment committee every time it meets than to have something that just sits in a drawer gathering dust that an agency or a participant may find and use as a sword in future disputes. The investment policy statement, the crux of the investment policy statement should be all of the selection and monitoring criteria. For example, it should identify what the investment performance benchmarks are. It should identify if there are any asset classes that are off limits for investment. It should set forth the plan objectives and goals. And then it should have guidelines for the fiduciary to follow for assessing performance and making decisions to replace or terminate different investment providers. Let's see. Oh, here, this slide here, I'm not going to cover it, but these are some DOL considerations when selecting funds and investment providers. These are good questions to be asking about the investment, whether it's a mutual fund company or an active manager. These are good questions to have to be answering as you make those assessments. And then, as I mentioned earlier, just on this slide, the important point is that investment options should be monitored at least annually. More frequent review is a best practice. I would say quarterly reviews are very common, especially in larger plans that offer a lot of investment options. But that is it's not mandated by ERISA. And then another, just as a point, a brief point, an employee stock ownership plan, an ESOP, is not a common type of retirement plan. It's a defined contribution retirement plan that is designed to primarily invest in employer securities. There are a number of additional regulatory requirements that apply to ESOPs, and a recent Supreme Court case has clarified that there is no presumption of prudence for an ESOP. There is no presumption that the investment in company stock is prudent, which had been, previous courts had said that did exist. So if your organization does have an ESOP or sponsor an ESOP, you work with an ESOP, it's important to keep in mind that the investment in employer stock still needs to be monitored just like any other investment option. ERISA bonding and insurance. So one is required, one is optional. ERISA requires that all employee benefit plans have a fidelity bond to protect the plan against losses resulting from fraudulent acts or dishonesty. Sometimes it's called a crime policy. It's something that it's a document, or the fidelity bond is something you have to have, and annually the Form 5500 requires that you report that you have one and the amount of it. In fact, we sometimes see that this requirement has existed since ERISA was enacted in 1974, and we have sometimes seen problems where maybe through just lack of attention to detail, the fidelity bond has lapsed, or the fidelity bond doesn't cover the right plan. Maybe you put in an ESOP, for example, and you forgot to add it to your fidelity bond. So issues can arise. It's something that has to renew either renews annually, or there are some fidelity bonds that renew every 3 years. Every time you renew your fidelity bond, somebody should double check to make sure that it covers all the plans and the amount is sufficient to comply with the ERISA requirements. Fiduciary liability coverage, however, fiduciary liability insurance is not required. It is permitted by ERISA, and the purpose of it is the insurance policy protects the fiduciaries against allegations of fiduciary breach. Another way to protect yourself is an indemnification clause in either a plan document or a separate indemnification agreement. There are limitations on the indemnification for ERISA fiduciaries. ERISA does not allow a plan spot or anyone to indemnify a fiduciary for a breach. It's designed to prohibit the encouragement of fiduciary breaches. So, for example, an employer can't say, I know this is a breach of fiduciary duty, but we'll indemnify you, do it anyway. So that's where that prohibition comes in, but there are exceptions for the fiduciary liability insurance coverage. And there is some limited indemnification that is permitted. So, hot topics. We'll go through some of these. I was going to spend a fair amount of time on the Fiduciary Rule, but I'm not anymore because for a political reason. So this rule, the Fiduciary Rule, was published on April 6, 2016 by the DOL, expanding the definition of who could be a fiduciary. And the primary impact of the rule was to bring in a whole lot more investment advisors than previously were considered fiduciaries. This is not a popular rule with Republicans as a party platform issue, and because of the results of the recent national election and the fact that Republicans now have control of the White House and Congress, I would imagine that there are going to be changes to this fiduciary rule, whether it's outright repealed, they significantly overhaul it. It is set to go into effect on April 10th, 2017. I know that President-elect Trump has put out his first 200 days plan. I don't know if this is on it. I think he's got other fish that he's focused on frying first. So it's possible that the rule will go into effect, but then I would not be surprised if there were significant changes to it. Just as to briefly cover what the new fiduciary rule provides is that a person will be a fiduciary if the person receives a fee or compensation for providing investment recommendations or recommendations regarding investment-related activities and policies. And this is a lot broader than the prior 5-part test, which is listed here for what investment advice. Previously, you became a fiduciary if you provided investment advice for a fee. This 5-part test was the prior test, and now this is the new fiduciary rule. As far as employee benefit plans sponsored by employers, you're probably not going to notice a lot of difference. This rule really affects those advisors to IRA holders. Those individuals are now going to be fiduciaries, and it may impact how some of the major organizations who provide investment consulting or record-keeping services proceed in the future. So I'm aware that a lot of the a lot of the major investment advisory companies out there are currently working through how they're going to comply with this rule. And for plan sponsors, our advice has been just kind of wait and see what is presented to you and evaluate that when you receive it. So we'll skip through a lot of these fiduciary rules. Revenue sharing. This remains a significant issue. It is part of almost every new 401k plan lawsuit. There are usually allegations about revenue sharing and that it was impermissible. Revenue sharing are payments from plan investments to record keepers that are often used to offset or pay for plan expenses. The DOL issued this advisory opinion confirming that revenue sharing is not always a plan asset. Of course, the arrangement can be structured where it would become a plan asset. The determination of whether these revenue sharing payments from the investment company to the record keeper are plan assets is based on the ordinary notions of property rights. And the important thing to walk away from or to take away with revenue sharing is that the plan fiduciaries have to understand what it is, what investment options have revenue sharing associated with them, and how that flow of funds works. Again, knowledge is power. Knowing and understanding how those things operate allow the fiduciaries to better evaluate and document the decisions to use that revenue sharing. Float income is a type of income that record keepers often retain. Usually arises in one of two contexts: either when investment directions are received after the end of business day and amounts are held uninvested for usually overnight. Usually record keepers hold them in interest-bearing accounts, omnibus interest-bearing accounts, and then also float income is realized when distributions are made from a plan. So if the record keeper writes a check to a participant, and while that check remains uncashed, those funds are usually held in an omnibus interest-bearing account, and the record keeper typically keeps all that minimal interest. Float income is typically not a plan asset. Participants don't suffer any harm, but it is something that, again, plan sponsors need to know about, need to understand, and need to address that they've reviewed it and understand it in order to protect themselves against allegations if the participants could make. Reasonableness of fees, we've discussed, I've brought this up a couple of different times during the presentation. ERISA requires that a plan pay no more than a reasonable fee to any service provider. In order to do that, fiduciaries have to understand what fees are being charged for any particular service. There are direct fees, there are indirect fees. The 408B2 disclosure referenced here is a great asset to help to understanding those fees. It is only required to be provided, however, to certain service providers, to retirement plans. Health and welfare plans do not currently have a similar mechanism to identify the different types of direct and indirect fees that their service providers might be charging them. That may or may not be coming down the line. The 408B2 disclosures were initially effective in 2012. It's something that, as a retirement plan, the plan fiduciaries should be receiving both before entering into a new arrangement with a covered service provider and also any time the contract renews. Okay, and then I'll just leave this up there for your consideration. These are different factors to consider when evaluating whether fees are reasonable. Fees don't have to be the lowest fee. The fee has to be reasonable in light of the services provided. So it might be reasonable for a very large 401k plan with tens of thousands of participants and hundreds of millions of dollars in assets to pay a higher fee, a certain fee, and it would be that same fee might be unreasonable for a plan with, say, a few hundred participants and a few $1 million in fees. So it's all relative. Fees are relative, and the plan fiduciaries are allowed to consider the different types of services and the complexity of the plan when evaluating whether something is reasonable. You know, and I think in the interest of time, we have 5 minutes left. I am going to skip over target date funds. Just the only thing I'll note here is target date funds are the most popular type of qualified default investment alternative offered in a 401k plan. Fiduciaries typically offer this. Fiduciaries in a 401k plan often want a qualified default investment option in their plan because that is any investments made defaulted into that option receive fiduciary protection under ERISA. There are certain limitations on what type of investment options qualify as a QDIA. Target date funds are typically one of them, and they are very popular because it's again a kind of a set it and forget it QDIA. The investment goes into the age-appropriate fund, and then that fund journeys. As it journeys along, the fund automatically rebalances, moving from more aggressive to more conservative as the population in the fund ages. These are very popular. They have received a bit of scrutiny from both the Department of Labor and the SEC because there are no uniform standards to be applied to design these target date funds. So not all target date funds are alike. Not all target date funds charge the same fees. Not all target date funds have the same what they call a glide path, which is how the fund reallocates and rebalances as the population ages. So the takeaway for target date funds is that a plan that offers a target date fund as a QDIA should be continuing to monitor those target date funds just like they do any other investment option in the plan. I think that's it. So as we have a couple of minutes left, anyone have any questions? Yeah.
Are record keepers required to report
the question is, are record keepers required to report float income? And the answer is no. They often will disclose that they retain it, but they won't they don't often voluntarily report how much they're retaining. Float income is considered part of the compensation paid to the service provider. So very often, for example, when I'm negotiating a contract with a record keeper, I do try to insert an obligation into the contract to periodically disclose float income, the amount of float income. It's sometimes successful, sometimes not, but being proactive and asking those questions as a fiduciary is still better than nothing. All right. Okay, let's see. A couple of questions from the, I think one of these I addressed. All right, let's go with this one. How do members of a corporate board of directors determine whether they're acting in a fiduciary capacity or making a business decision? A board of director, anyone really, who is acting as the decision of whether you're acting as a fiduciary is based on whether you're making a decision about either the administration of an employee benefit plan or anything having to do with plan assets, the use or investment or any activity relating to plan assets. If the decision, I would say if the decision is related to either of those two things, you're probably acting in a fiduciary capacity. Anytime a board of directors, in contrast, is acting to make a plan design decision, whether to, for example, terminate a plan or to, in a pension plan, very common board of directors action these days is to freeze or terminate that pension plan. Those are settlor decisions. Those are not fiduciary decisions. And when making those types of decisions, boards of directors are free to consider the business implications of that decision and to actually have that be their primary motivating factor. But anytime a board of directors is administering a plan, which again we would probably advise that they not be doing, that's an activity that really should be delegated down to at least an officer of the organization, or possibly even a committee of employees. That would be a fiduciary decision. So I think that is the end of our time. Thank you very much. It's been a pleasure talking to you today, and have a great rest of your day.